It is a quiet evening in Melbourne, Florida. Nothing unusual. No sirens. No emergency. Just a neighborhood settling into the night. And then, an anonymous caller picks up the phone and tells dispatchers that a man and a woman are arguing loudly at a nearby home. The caller mentions no weapons. No violence. No threats. Just voices, raised voices, coming from inside a house. That single phone call is about to set off a chain of events that ends with a man on the ground, a fractured rib, a trip to the hospital, an arrest, a lawsuit, and a department-wide reckoning over whether officers are even being trained correctly on one of the most fundamental principles in American law. On the night of March 15, 2024, officers were dispatched to the Melbourne home of Andrew Dixon and his girlfriend. The dispatch report noted that a male voice had been heard yelling, that the male was known in the neighborhood for occasionally drinking and getting into arguments, and that no weapons had been mentioned by the caller. 2 officers were sent to investigate, Officer William Gould and Officer Zachary Proctor. When they arrived, they found Andrew Dixon standing quietly outside the home. Alone. Calm. Not yelling, not intoxicated, not causing any disturbance. Just a man standing outside his own front door. The officers made contact with him, and the interaction that followed was recorded on body camera. The officers explained they had received a call about arguing. Dixon told them calmly that there had been no argument, that he was just outside getting some air, and that his girlfriend was inside. He called her out, and she came to the door. She was calm too. Neither of them showed any signs of distress, injury, or conflict. Both spoke to the officers independently. The scene was entirely peaceful. And then the officers asked for identification. Now, this is the moment where everything began to go wrong, not because asking for ID is inherently unreasonable, but because of the legal framework that governs when an officer actually has the authority to demand it. In Florida, that authority comes from a statute commonly known as the Stop and Frisk Law. Under that law, an officer may temporarily detain a person and require them to identify themselves only when there is reasonable, articulable suspicion that the person has committed, is committing, or is about to commit a crime. That standard was further clarified by the United States Supreme Court in a 2004 decision, where the court confirmed that while states may constitutionally compel identification during an investigatory stop, the stop itself must be lawfully grounded in that reasonable suspicion. In other words, an officer cannot simply declare that an investigation is underway and use that declaration as the legal basis to demand your name. The suspicion has to exist first, and it has to be tied to actual criminal conduct. Here, there was a significant problem with that requirement. The entire basis for the officer's presence was an anonymous tip reporting a loud argument. That's it. And under well-established constitutional law, anonymous tips carry very little legal weight on their own. A 2000 Supreme Court decision addressed precisely this issue, holding that an anonymous tip must be reliable not just in identifying a person or a location, but in its assertion of illegality. A tip that someone might be arguing, without any additional corroboration, without predictive information, without any indicia of reliability, does not, on its own, give rise to reasonable suspicion of a crime. But even setting the quality of the tip aside for a moment, there is a second and perhaps even more decisive problem. Even if the officers had arrived at the scene with some level of valid suspicion, by the time they demanded identification, that suspicion had been entirely dispelled. Both Dixon and his girlfriend had spoken with the officers separately. Neither appeared injured. Neither was distressed. There was no evidence of any ongoing or past criminal conduct visible anywhere at the scene. The Supreme Court has recognized that an investigatory detention must last no longer than necessary to address its purpose. A 2018 Florida appellate court applied that principle directly, holding that if an investigation dispels the concern that gave rise to it, the detention can no longer be legally sustained. The concern here, that 2 people were arguing, had been resolved the moment both people appeared calm, unhurt, and cooperative. Dixon, for his part, understood this. He pushed back on the demand, asking repeatedly what legal authority the officers had to require his identification. He was not aggressive. He was not threatening. He was asking a question that was, by any measure, legally valid. The officers, however, interpreted his refusal as obstruction and escalated the situation rapidly, first warning him that he could be arrested for refusing to identify himself, then telling him this was his last chance, and ultimately initiating a physical arrest. What happened next unfolded in seconds. The officers attempted to take Dixon into custody. Dixon did not strike either officer, did not threaten them, did not attempt to run. The officers later reported that during the struggle, Dixon reached toward his waistband, which they described as an officer safety concern. Based on that, Officer Gould delivered multiple knee strikes to Dixon's ribs to regain control of his arm. Dixon was taken to the ground and ultimately handcuffed. When officers searched him, they found his wallet in his pocket. His identification had been on him the entire time. Dixon was transported to Melbourne Regional Hospital. He had a fractured rib and lacerations on his legs. After being medically cleared, he was taken to the county jail and charged with 2 counts of resisting an officer without violence, 1 count for refusing to identify himself and 1 count for physically resisting during the arrest itself. Both charges were dropped by the prosecutor less than a month later, on April 12, 2024. Now, before examining the constitutional analysis of the use of force, it is important to understand how courts approach these situations when both a false arrest claim and an excessive force claim arise from the same incident. Courts treat these as 2 independent questions. Even where an underlying arrest is found to be unlawful, a court will separately evaluate whether the manner in which that arrest was carried out was itself constitutionally excessive. The 2 questions do not collapse into each other. The governing test for excessive force comes from a 1989 Supreme Court decision, which established what is called the objective reasonableness standard. Under that framework, courts ask whether the amount of force used was objectively reasonable given the facts and circumstances that the officer faced in that moment. Relevant factors include how serious the suspected crime was, whether the suspect posed an immediate threat to the safety of the officers or anyone else, and whether the suspect was actively resisting or attempting to flee. Applying that framework here presents a genuinely difficult question. On one hand, Dixon would have strong arguments that the force was disproportionate. The crime alleged was resisting without violence, one of the lower-level misdemeanors on the books. The officers had no information that Dixon was armed. Dixon had not struck, threatened, or lunged at either officer at any point in the encounter. And the injury that resulted, a fractured rib, was serious. On the other hand, if a court accepted the officer's account that Dixon was reaching hard toward his waistband during the struggle, a court could potentially find that the officers faced a genuine officer safety concern in that moment and that the knee strikes were a targeted response to regain control rather than punishment. That question would likely turn on the specifics of the body camera footage and the credibility of witness accounts. But what cannot be disputed is the sequence of events that led to the use of force in the first place. There was no lawful arrest. And there was no lawful arrest because there was no reasonable suspicion. And there was no reasonable suspicion because the officers had responded to an anonymous tip describing conduct, a loud argument, that is not a crime. The department's own internal review made exactly this determination. A lieutenant who reviewed the case raised concerns with a commander. That commander, Commander Most, submitted a formal discipline memorandum to the chief of police concluding that the officers had no reasonable suspicion to demand identification, that the arrest lacked probable cause, and that the use of force resulting in injury was not proper. Commander Most also reached out to the state attorney's office, where the division chief for the misdemeanor division reviewed the footage and independently reached the same conclusion: no reasonable suspicion, no probable cause, no lawful basis for what had happened. The commander's memorandum also identified multiple specific policy violations. Officers were required under department policy to observe and comply with all persons' clearly established constitutional rights. They were prohibited from exceeding lawful officer powers through unreasonable or unlawful conduct. And supervising officers were required to intervene and report when another officer used force clearly beyond what was objectively reasonable. Following a predetermination disciplinary hearing, both officers Gould and Proctor accepted full responsibility for the unlawful arrest. They stated at the hearing that they had genuinely believed at the time that they had the legal authority to demand identification, and they said something that should give anyone pause. They expressed concern that other officers on the force might make the same mistake because of how they had been trained. They believed the misunderstanding of the law was not isolated to them alone. The discipline ultimately imposed was lighter than the commander had recommended. Each officer received a 6-hour suspension without pay. They were also required to work with the department's training unit to develop a roll call training on the legal limits of requiring citizens to identify themselves, a training that, apparently, was overdue. On March 12, 2026, Andrew Dixon filed a civil lawsuit in federal court against both officers, the supervising sergeant, and the chief of police, asserting claims of false arrest and excessive force under both federal and state law. As of this writing, that case remains pending. What makes this encounter particularly worth examining is not just what happened to one man on one evening in Florida. It is what the officers' own statements at their disciplinary hearing reveal about a broader institutional problem. 2 officers went into a situation, demanded identification they had no legal authority to demand, escalated to a physical arrest they had no probable cause to make, and injured a man in the process, and they did all of it because they believed they were acting within the law. They were not being malicious. They were operating under a misunderstanding. And that misunderstanding, if it was embedded in how they were trained, means that countless encounters before this one may have unfolded the same way, just without the same level of scrutiny. The authority to compel identification is not activated by an officer announcing that an investigation is underway. That idea, however commonly held in practice, is constitutionally incorrect. The authority is activated by the existence of reasonable, articulable suspicion of actual criminal conduct. That is the standard. It has been the standard for decades. And when officers act as though the standard is something different, real people, people standing quietly outside their own homes, end up on the ground with broken ribs. Dixon, for his part, understood the law better than the officers who were enforcing it. He knew he was not required to identify himself. He said so repeatedly. He remained relatively calm throughout a situation that escalated quickly and dangerously around him. Once the physical arrest began, he did tense his body and pull his arm away, which carries its own legal risk regardless of whether the underlying arrest was valid. But the force that followed, and the injury that resulted, came from a decision the officers made, a decision to arrest a man they had no authority to arrest. And that is the weight of this encounter. Not just the legal analysis. Not just the policy violations, but the simple, undeniable fact that a man went outside to stand in front of his house one evening, did nothing wrong, and came home from the hospital with a fractured rib and 2 criminal charges that were later thrown out. The system eventually corrected itself. The charges were dropped, the department opened an investigation, the officers were disciplined, and a lawsuit was filed. But none of that undoes what happened on that night,